Thank you very much, David. On behalf of the China Help Desk, I'd like to thank the EU SME Centre for inviting us and giving us the opportunity to speak to you all this morning. We always appreciate our, as David mentioned, multiple opportunities to collaborate and spread the word on intellectual property rights in China. So you've heard, my name is Simon Cheetham. This is me. I'm the team leader for the China IPR SME Help Desk. I'm kind of fortunate in that I've been in that role since the inception of the Help Desk. So going back over a decade now, and we're up to the 7th phase of the project. And I think its longevity really speaks to the practical support and help that it's been able to deliver to SMEs. So before I get into the topic in a little more detail, just a few words about the Help Desk. It provides free support and advice to SMEs, and geographically it covers not just China, but Macau, Hong Kong and Taiwan, and these are all separate jurisdictions with separate legal systems. So it's quite important to draw the distinction between them. A key service that the Help Desk provides is the confidential advice that it gives to SMEs, and we pride ourselves in responding within 3 working days, and always encourage any business to contact us via the email shown on the slide, or indeed by telephone, if that's more convenient to them. We've been able to adhere to that 3 working days policy very, very well. And very close to 100% of our inquiries are responded within that time period. So a quick and fast response can usually be expected from us. Just to explain what the Help Desk provides in a little more detail, we attend trainings and workshops to provide informative advice to SMEs on sector issues and on different aspects of intellectual property rights. A key service, though, is the one-to-one consultations for businesses. So if you're an SME and you're looking to do business in China, or indeed if you're an organization representing SMEs and you want them to have some specific advice on China, then we are happy to organize consultations with the China IP business advisor, who's well experienced and can spend some time discussing the issues and the strategy that would best suit the business involved. And these can be very, very productive sessions, so we do really encourage businesses to reach out and make use of them. A lot of self-learning materials are also made available, and you can download guides, which I'll demonstrate in a minute, from the website. And there are various IP tools and other means of staying in touch, including our IP blog. This slide just shows a couple of guides. The guides deal with different aspects of intellectual property rights in China, but also provide information for sectors, different industry sectors, and indeed, in some cases, different situations. For example, if a business wanted to seek legal advice in China, there's a guide to help guide the business in the best way to do that. So all this information is available via the website. It's all free, and we do, as I say, recommend businesses make the best use of it. Of course, the China Help Desk is part of a larger support network. There are, in fact, 6 help desks throughout the world that are provided by the European Commission, including in Southeast Asia, in Africa, and in Latin America, and of course in Europe. So you have the resources there available to you to really cover almost any international arena as far as intellectual property rights and advice are concerned. The way to access any of those help desks is via the link shown on the slide, ec.europa.eu/IP-help desk. That will take you to the gateway to any of the help desks that you may need advice from. And finally, these are some of the ways in which you can stay connected with the China Help Desk, and we do encourage you to make use of them if you can, and you would like to follow us and the various activities and events that we are involved in and planning and which are coming up. So that was a bit about the Help Desk. And now I'd like to turn to the topic this morning on intellectual property rights and on the developments and trends and changes that are occurring in China at the moment. We've heard quite a lot already about data and cyber security, and these, of course, are hot topics in many respects. So I'll touch on some aspects of those too, but then go on to talk about how the regulatory changes and trends affect businesses through some current IP issues, which are probably best demonstrated by examples of the kind of inquiries that we've received at the help desk, and then wrap up with some tips and takeaways at the end. So to perhaps introduce the topic in a way, we can talk about the drive for innovation in China. I think we all understand some of the milestones now that have been well reported and exemplified on the slide up there. But the point is that China needs continued growth to become a medium-level country in terms of GDP per capita. And what does that mean? Well, that means that China aims to double its 2020 GDP to achieve this status by 2035. China has a top-down government, and it set out its 14th five-year plan centering around a dual circulation strategy, which was first articulated by President Xi Jinping back in May 2020, as China began to plan its economic recovery growth, driven primarily by a strong domestic demand and combined with exports based on advanced manufacturing. Chapter 5 in that plan describes plans for building a digital China. So just a reminder, these have been articulated before, but these deal with 7 core industries at the forefront of the plan. Cloud computing, big data, the Internet of Things, industrial internet, blockchain, artificial intelligence, and virtual and augmented reality. And the 10 areas where this tech should be applied, according to the plan, include smart transportation, smart energy, smart manufacturing, smart medicine, and smart government. We can see this coming into effect already in day-to-day life in many cases in China. And in this context, changes are being made to IP laws in China. And this is leading to a steady upgrade in the intellectual property rights regime. And the factors which seem to be driving this change include China's accession to different trade agreements, a recognition that innovation is really key to increasing value, and is another key component of growth, and innovation can only flourish under an effective intellectual property rights regime. And note that there's a focus on employing China's fast-growing domestic market and powerful regulatory regime to decrease reliance on foreign technology and develop indigenous technologies, and as a result, enhance both its economy and national security. So with this in mind, let's take a look at the developments in China's IP regime. It seems a long time ago, but actually China officially ended its zero COVID policy just last year, so not actually that long in terms of the calendar time. But the theme here is big developments. In the last 6 years, there's been restructuring of the IP registration management and enforcement government bodies in China, and that's been part of a bigger reorganization, which was originally announced back in March 2018 at China's Two Sessions meeting. So this has meant merging together the State Intellectual Property Office and the China Trademark Office under the China National Intellectual Property Administration. That's the CNIPA. And more recently, looking at the changes to the laws, in December 2023, China's State Council released the amended implementing regulations of the patent law, which came into effect in January this year. And these regulations introduce changes in line with international norms, like restoration of priority and the deadline regarding re-examination, the good faith principle, and publication of patent evaluation reports, allowing for more flexibility for patent applicants. They also give more details of the new mechanisms introduced by the 2020 amendments, such as deferment of patent examinations, invention patent term adjustment, and drug patent term extensions too. And then in December 23, the CNIPA released the patent examination guidelines in conjunction with the implementing regulations of the patent law. And these also came into effect in January this year. So the guidelines introduce a preliminary inventiveness examination of utility models, which has in practice actually been in use since 2023, but made official by the guidelines. It's interesting to note that in 2023, there was a 25% decline in utility model grants, which, as you may suspect, was related to the changes to implement the preliminary inventiveness examination of those models. So it seemed to cut out a lot of spurious utility model applications. And then in April 2024, the CNIPA announced its participation in the Patent Prosecution Highway Improvement Initiative, which involves the cooperation among the 5 major intellectual property offices, being the USA, the EU, Japan, South Korea, and China. And the goal of this initiative is to achieve an average processing time of 3 months between the granting of a patent prosecution highway request and the issuance of the first office action, as well as an average response time from the examiner to the applicant not exceeding 3 months. So these are positive steps. I was going to delve into data in a little more detail, but having heard Tom's excellent presentation this morning, I'm very pleased to relate that he's covered much of that topic already, and I wouldn't consider trying to add much to it, except I do have a couple of comments though, and one relates to the issues surrounding classifying personal information as sensitive in the China concept. It's basically the obligation of the data processor to classify whether personal information is sensitive or not. And while the Chinese authorities retain the right to review the classification, it is nevertheless the obligation, as I say, of the data processor to make that first decision. So one can only refer to the Personal Information Protection Law for the definition of what sensitive information actually means. And Article 28 of the Personal Information Protection Law states that sensitive personal information is personal information that once leaked or illegally used may easily lead to the infringement of the personal dignity of a natural person, or may endanger his personal safety or property, including information such as biometrics, religious belief, specific identity, medical health status, financial accounts, and the person's whereabouts, as well as the personal information of a minor under the age of 14 years. So that's the only definition, really, that we can fall back on at the moment. And what does that mean? Well, in practice, it's quite complicated for companies to decide whether personal information is sensitive or not. Take an ID number, for example, or a personal photograph, or even dietary preferences. These might be sensitive in one situation, but not in another. And so far, there's no clear definition of sensitive personal information on its own in any of the current laws and rules in China. So in practice, you're left with this issue of deciding on a case-by-case basis, which is what is happening with the authorities at the moment. It's decided on a case-by-case basis, and these uncertainties do make compliance more challenging for companies. So just a couple of maybe additional recommendations for EU SMEs in China around this particular topic on data. It is important, as you've heard, concerning thresholds and looking for exemptions, to conduct necessity tests to evaluate if the exemptions fit, and to continuously monitor exported data in case data exceeds the given thresholds. And we think that for EU SMEs generally, it should be relatively easy to keep within the scope of the exemptions in that respect. The regulations may not apply to EU SMEs not located in China, so there the priority should not be so much cross-border data transfers, but the Personal Information Protection Law, which is extraterritorial. So to comply with the Personal Information Protection Law, SMEs should prioritize updating their privacy policy and reviewing their consent language as well. In China, local data storage requirements mandate that certain types of data must be stored in China, and that could be a considerable burden for SMEs as well. Although some experts do think that the Chinese authorities do prioritize the Personal Information Protection Law and data transfers when regulating data protection, while local data storage in China may not be as important. And this may also be why the rules and regulations around data storage are still rather vague. But as Tom has pointed out, this is an area of ongoing interest and ongoing development. So I guess it's a case of watch this space. Interesting, we heard comments about, or a question indeed, in this morning's session on China's influence on data regimes in other countries. So that's rather coincidentally, I'm going to talk a little bit about a comparison between China and EU in terms of data protection policy. And some experts are of the view that the Personal Information Protection Law, the Data Security Law, the Cyber Security Law, and the regulations on the security protection of critical information infrastructure have all transplanted some of the core concepts and the typical systems of GDPR to varying degrees. The standard contract for the export of personal information and the measures for the security assessment of data export used in China's pre-approval procedures also draw lessons from the EU's standard contractual clauses and data protection impact assessments. So it does seem as though China has taken on board, assimilated, and used some of these tools, if you like, from the EU. So although China has a robust data protection framework compared to Europe, China places more emphasis on protecting national security data and trade facilitation, with two main focuses on state control and on rapid technological development. And these are also the main focuses on the AI law. But China's protection of personal information is not as stringent as the EU, where rules and regulations more focused on protection of individual rights, ethical considerations, and a more structured approach to innovation. So you've got a different focus of data law in China compared with the EU, which leads to different regulations and rules. In terms of personal information, detailed requirements of personal information are different in the EU and China. For example, under the Personal Information Protection Law, the scope of sensitive information includes financial accounts and individual location tracking, but that kind of information is not deemed sensitive personal data under GDPR. In the case of data infringement, multiple cases where defendants were ruled to have violated the anti-unfair competition law for using bots and crawlers to collect publicly available data from websites, even if the data itself was not copyrightable. And the courts in China invoked general competition principles, arguing that such scraping activities may infringe the data interests and competitive advantages of the plaintiffs. So designating data scraping as an unfair competition issue may enable higher compensation claims compared to conventional service agreements, which, if violated, typically do not stipulate specific compensation amounts. And there's the notable example, which you'll probably recall, is the Weibo case, where the defendant was fined 20 million renminbi for illegally scraping and reselling user data from the social media platform. In the EU, the data scraping is more commonly viewed as a potential violation of terms of service agreements or even trespassing claims. In China, the anti-unfair competition law empowers authorities to regulate data scraping activities, even in the absence of explicit consent or terms of service violations prohibiting such behavior. And again, different from the EU, in China, all large model products intended for consumer use must undergo security training, testing. And the purpose of these tests is to ensure that the content generated by these models aligns with Chinese societal values. And the providers of the non-compliant large model products may face fines or indeed be required to cease providing services to the public. Under GDPR, the standards of data protection in the EU are relatively uniform. In China, data protection is primarily regulated by the Personal Information Protection Law and the Data Security Law, as well as various rules and regulations which have been launched over the years. And the number of rules and regulations makes it more difficult to navigate the data protection landscape in China. Again, this is something that Tom has alluded to. In terms of AI and data, China's approach to AI regulation is really via a dual focus on fostering innovation and maintaining state control. This is consistent with their data regulations. The new generation, I should say, artificial intelligence development plan, which was actually issued in 2017, outlined a strategy to become a global leader in AI by 2030, promoting rapid technological advancement while ensuring alignment with state interests. On the other hand, the control of content is still relatively strict. Contents that violate public policies and harm public interest, which have been generated and published by a specific user of one AI tool, may lead to the punishment of both the user and operator offering the AI tool service, or even the basic model developer. And in terms of enforcement, courts have not really reached a unified position so far, or a unified opinion on the issues arising from the AI technology. And this includes the nature of the AI, the ownership of content generated by AI, obligations in a conflict or an infringement situation, and so on. But in contrast, the EU's Artificial Intelligence Act adopts a more structured approach, categorizing AI systems based on risk levels and imposing requirements accordingly. The EU emphasizes ethical AI development with a focus on transparency, accountability, and compliance with GDPR principles. And this regulatory framework aims to ensure responsible AI development, prioritizing ethical considerations over the pace of technological innovation. I think that's quite important to note because that's quite a different approach between the EU and China in that respect. Of course, AI data are not the only IP-related laws that have been updated and changed. And so taking a look at some of the others, regulations on the protection of geographical indication products, which came into effect in February this year, emphasize the good faith principle in GI examination and stipulate that the detailed GI examination process and clarify the examination and approval process by the CNIPA, which was previously managed by the General Administration of Quality Supervision, Inspection and Quarantine, which was AQSIQ for those who perhaps know the abbreviation. And the regulations focus on the administrative procedure, but do not provide any information on the civil procedure. So that is yet to be developed. For the protection of overseas GIs in China, the regulations clearly state that they are not covered in those regulations, and there'll be another provision or regulation issued by the CNIPA. I should also point out that the amendment is still lacking some specific provisions concerning the administrative enforcement of rights over GI products. And this is partly due to the administrative reorganization. The CNIPA is now directly under the State Council and has no direct authority to draft measures concerning enforcement. The administrative enforcement of GI products should come from the State Administration for Market Regulation. So no specific regulation is currently foreseen from the SAMR, but it seems that a law on GIs is in the making. That's a kind of an unofficial view. In May this year, during Xi Jinping's visit to France, the CNIPA renewed the protocol on cooperation in agricultural and food geographical indications with the French Ministry of Agriculture and Food Sovereignty and the French National Institute of Origin and Quality. Both China and France agreed to further deepen cooperation in the field of GIs, which is encouraging. And in a joint statement on agricultural exchange and cooperation between China and France, both sides welcomed the strengthening of cooperation through the renewal of the GI Cooperation Protocol. Having said that, in August this year, a couple of months ago, the Ministry of Commerce of China said that it would launch an investigation into the subsidies given by the EU and EU member countries for their dairy products that could lead to tariffs on their export to China. So it almost looks like a kind of a wavering in terms of that direction of policy. In September last year, the CNIPA issued the guidelines regarding trademark assignment procedure. And this was basically to highlight the risks in trademark assignment. The guidelines are aimed at preventing hoarders from being able to assign trademarks to potential buyers who, in turn, are really encouraged to conduct thorough due diligence when negotiating to buy these trademarks from assignors. And in May this year, the State Administration for Market Regulation announced the interim regulations on anti-unfair competition on the internet. And these are aimed at preventing and curbing unfair competition online and promoting a healthy development of the digital economy. The interim provisions are effective from September, so it's obviously too early to say what impact they are having. Perhaps this time next year we can comment on that. So, looking ahead, and China is basically maintaining its momentum of change. There are 7 laws and regulations undergoing revision, with at least one round of call for public comments on each of these. So we have the trademark law and the implementing regulations of the trademark law, the regulations on the protection of new varieties of plants, the anti-unfair competition law, e-commerce law, the implementing regulations of the copyright law, and the regulations on the collective administration of copyright. So a lot is in the pipeline. A lot will be happening, and there will be more changes. Turning to artificial intelligence, again, these are areas that have been addressed this morning in some degree or another. The interim measures for the management of generative artificial intelligence services was issued by the Cyberspace Administration of China in 2023. These pose certain obstacles for EU SMEs, and it's this aspect I wanted to address. If generative AI services have public opinion attributes or social mobilization effects, before providing these services to the public, services providers have to apply for a government security assessment and a filing of the associated algorithm. And these are supervised and coordinated by the CAC. The CAC has the same requirements for recommendation algorithms as well. And in some recent cases, several AI products have been taken down because they were not registered in advance. So, you know, it sort of feels as though there is a steady move to implement, tighten, control those regulations. And so, of course, the obvious question here is which services may have public opinion attributes, and you may also ask, or which services may have the capacity for social mobilization. It sounds all a bit vague. So to better understand that, I think we have to refer to Article 2 of the Regulation on Security Assessment of Internet Information Services, having public opinion attributes or social mobilization effects, a very catchy title. And that was issued by the CAC back in 2018. So according to that, such services include forums, blogs, microblogs, chat rooms, newsletter groups, public accounts, short videos, streaming, information sharing, mini programs, and so forth. The registration process requires submission of reports on the AI model, demonstrating how it prevents the generation of harmful content. However, the source code or model parameters are typically not requested. I've heard some with experts with the view that the CAC may relax this requirement and change the registration from mandatory to voluntary. So, but this is not officially confirmed, and even if the registration becomes voluntary, then, okay, it could potentially ease the compliance burden for EU SMEs offering AI services in China. But nevertheless, SMEs would still need to ensure that their AI models align with Chinese regulations on content governance and ethical AI principles. So, yeah, there's still a lot to contend with there. So moving on to some sort of green tech related issues. In August this year, the Communist Party of China Central Committee and the State Council unveiled guidelines to ramp up green transition. And so the aim is by 2030 that the scale of the energy conservation and environmental protection industry will reach about 2 trillion euros in size. And the proportion of non-fossil energy will increase to about 25% of energy consumption. and the carbon emission intensity of commercial transport will drop by about 9.5% compared with 2020, and so forth. And the guidelines highlighted the importance of innovation and IP. And innovation is one of the 4 key elements to support this transition. So China will clearly be pushing and facilitating the IP system to create and exploit the green IP is intrinsic to innovation. And by 2035, a green, low carbon and circular development economic system will basically have been established. That's the plan. With green production methods and lifestyles widely formed, and significant progress in synergy of pollution reduction and carbon reduction, and utilisation efficiency of major resources is planned to reach international advanced levels, with carbon emissions stabilising and declining after peaking. And geographically, the focus includes developments of the area Beijing, Tianjin, Hebei, the development of the Guangdong, Hong Kong, Macau, Greater Bay Area, and integrated development of the Yangtze River Delta, the construction of the Hainan Free Trade Port, and the ecological protection and high quality development of the Yellow River Basin. So huge targets ahead, but China has demonstrated time and again that it's able to meet these targets that it sets out. So I've pretty much covered the regulatory changes that have been happening and are planned in the near future. So how to perhaps address the impact that these regulations are having on SMEs. And I thought there are 2 ways of doing that. One is by looking at some of the inquiries that we received at the help desk. And this slide is a snapshot during the current phase of the help desk only, so from February last year through till now, when we have assisted around 1,000 EU SMEs on their specific individual inquiries. And this shows that there are quite significant interests in, well, you see trademarks and patents and copyright, and trade secrets, while smaller, does take up a significant proportion of the inquiries we receive. And the segment on general inquiries deals with SMEs that have perhaps strategic issues they need to discuss and get advice on approaching China in a more overall way that can't be pigeonholed into one of those particular categories. Incidentally, around 20% of our inquiries come through discussions, one-on-one discussions with our IP business advisor. So that really is a valuable tool for SMEs to make use of. And another significant proportion comes from attending trade fairs. So we do have China Help Desk representatives at trade fairs ready to talk to businesses as issues arise. And we do find that many take advantage of that, and it gives rise to a big proportion of our inquiries. So those are the kinds of issues proportionally that are coming up in China at the moment. But I've chosen a couple of live cases too to talk to you about, just to demonstrate what it's like on the ground, what's happening for businesses. And the first of these is about proprietary information, know-how, trade secrets. And this involves a German EU SME that's been in the China market for some 17 years as a tech provider for titanium dioxide and production of that. And it supplied 2 titanium dioxide pigment plants in China. The first plant was set up in Yunnan, and the second plant later with another company in Henan. But in 2020, the Yunnan plant went out of business, and it was bought by the second plant operator, the Henan company. So both plants were then operated by the same company. And the German business SME was very good and very careful at safeguarding their know-how, including technical documents, software, production drawings. specifications, operating manuals, carefully controlled and guarded as trade secrets. And these documents were delivered using double strong encryption, and even with triple encryption for some of the key equipment, and provided on a need-to-know basis. So they did all that they could do. And they even put in some hidden markers identifying their own IP within their tech documents that were used. So that was all a positive thing for them to do. But then in 2021, two former key employees of the first plant stole a significant number of documents and sold the technology to a third company in a different province in Hebei. And the company in Hebei used the stolen IP and in fact the service of the two former employees to build a new titanium dioxide plant without any consent or authorization. So in 2022, the Henan company filed a criminal complaint with the Public Security Bureau of the district where the original plant was located. That's the Yunnan plant. And the PSB, they did an investigation and obtained the drawings of an equipment supplier that was in the process of manufacturing equipment for this new plant. We'll call it Plant 3. And they contracted an expert witness. The PSB contracted an expert witness who concluded that the drawings that this new plant was making use of were an exact copy of the drawings supplied by the German company. So what did the PSB do? They issued an arrest warrant for both the former employees. And at the end of last year, one of the former employees was arrested and is currently awaiting trial. And we expect that to take place before the end of this year. But they couldn't find the second former employee. But despite all these legal problems, the infringing plant in Hebei province went ahead and installed the German company's technology and commenced production, and that caused over 10 million euros worth of damage and loss of business to both the EU business and its Henan partner. And unfortunately, the Yunnan PSB had or has limited authority to conduct investigations in a different province. And this requires coordination between PSBs in the different provinces. And the net result has been that the whole investigation has slowed down, and this is where we are now in this live case. Thankfully, the Germany SME has maintained its determination to enforce its trade secrets in China. They're pursuing other avenues to try and leverage more support, for example, with the German embassy and trade bodies as well. And they do realise that not taking any action could lead to more infringements. So what can we take away from this? Well, I think, first of all, protecting business information as trade secrets is essential if you've got trade secrets. The most common problem relating to trade secrets is leakage caused by former employees. So you must implement the best steps that you can, follow the need-to-know rule, restrict access so that only those who need to have access to the trade secrets, and only to the extent that it's absolutely necessary for them to complete those tasks. Make sure confidentiality agreements and non-compete and non-disclosure agreements are signed with key employees in China. And it's important also to agree with Chinese partners on a process to handle infringement of IP. You need to know who is going to take the lead in these matters. And it's best to have a plan in place before that happens. It's not cheap to enforce intellectual property rights in China. Attorney fees can easily be well north of 10,000 euros, but no action would certainly mean more infringements are likely, leading to even bigger losses. So that's the lesser of two evils in terms of use of resources. And finally, when encountering problems like this in China, we really do advise contacting IP experts to assist, whether it's with evidence collection or with designing a comprehensive enforcement strategy. Not worth trying to take any shortcuts when that happens. The China SME Help Desk does not provide legal assistance, but can certainly offer first-line advice on enforcement strategies for China, and hopefully assist with putting plans in place to prevent these issues happening in the first place. So that was trade secret case. And the other case I wanted to mention was really dealing with the online issues, which is a relatively common issue for SMEs that we speak to. This particular case, again, it's a live case, deals with counterfeit products being sold online. And this was a seller of trademarked caps using a mobile WeChat number for contact. So quite difficult to find out who was behind it. So back in May this year, the mobile WeChat number was found through some research to be linked to a Wuhan company account. And this was a garment company. And it was a company that had only been recently set up in March in 2022, but had been closed down in April in 2023. And then a check of the WeChat Alipay account real name verification, which is another thing that can be done, showed that the account matched the name of one of 4 shareholders, but unfortunately the name of the shareholder was a very common name in China. So, you know, a common name in China means millions and millions of people sharing the same name. But interestingly, the records, the business records showed that in 2022, after it had set up in business, this Wuhan garment company changed the nature of their business from manufacturing garments to internet sales of garments, shoes and hats only. And then a look at one of the other shareholders established that he was associated with 2 other companies in Hunan province, Changde city in Hunan province. Anyway, in the summer this year, investigators were contracted and contacted the seller on WeChat, who sent some photographs of fake caps, and some samples were sent, and a courier label showed an address in the same Changde city in Hunan province. But they were dispatched from a collection point inside a boiler factory opposite a gas station. So, you know, not much you can do with that information. So some of the caps that had been delivered were later returned, and the seller gave a different address to have some of the samples returned, also in Changde city. Meanwhile, the seller had mentioned that the factory that they were using was in fact in Guangdong province. And it took some persuading, but a visit was arranged to the factory. A meeting took place at a train station. And then the sellers led the way to a factory which just coincidentally or ironically happened to be located near to the Big Cap Creative Park. And that building there is the iconic building at the Big Cap Creative Park actually in Donggun in Guangdong province. Anyway, having visited this factory, there were some clues that seemed to suggest that it was not actually the seller's own factory. They had borrowed a factory to show rather than reveal their true location. Back to Hunan, and the name on the WeChat Alipay account and was actually linked to there through local research to a supermarket and 2 companies. Anyway, a long story short, the WeChat seller was eventually found to be someone who prepares braised food at a premises within walking distance of a family-run supermarket, which is his business. But provides financial backing to partners running the garment business from a nearby business incubation centre, and this incubation centre provides startups with free office space for 2 years under a preferential state and local government policy. So this group were operating on a 2-year cycle to get free rent, and then setting up a new business, and they were turning over several million RMB and were not paying any tax. And by registering new entities, they were able to add more rent-free periods. And this also has allowed them to try and evade online takedown actions. So I think this is quite a good example of the challenges that IP owners face when tackling these online infringement issues. I'm not sure how we're doing on time, but I think I'm just about ready to wrap up here. Just a few takeaway thoughts or comments. So if you're, these are the sorts of advice that we try to give to most SMEs that are considering going to China. It's so important to make a deliberate decision to go to China as part of a planned internationalization. And I think we are all familiar in this room, certainly, that you can't assume the law is the same as in your home market. There are obviously big differences between the regimes in the EU and in China. But in China, just a key point is that registration is almost everything there. You need to register your intellectual property rights in China, you need to do it early, and you need to do it broadly. And that way you have the tools at your disposal to retain the brands and the ideas and the know-how that have been developed. Also make sure that the rights that are registered are in your own name or in the name of your own business and not in the name of a third party or a local partner or another business in China. And on the trade secrets front, we've already heard the issues that we face, but I think as a general policy, it's quite a good approach. If people don't need to know about your latest developments or your tech or critical aspects of what you are offering, then don't tell them. Hold back on that information. And of course, you're always welcome to contact the China Help Desk for further advice, and we'll do our best to provide support and information for you. And that concludes my presentation, and this is just a reminder on how to stay in touch with us or contact us if you need any information from us. Thank you.
Do we have any questions coming from the audience concerning the IPR? Okay, I see we have one.
Just a small question. I'm Petra van Bouwelen from the Chamber of Commerce in the province of Antwerp. Thank you for your presentation. Just a small question. Did you mention that is there a decrease of infringements on IPR in China, or does it stay the same? Is it stabilizing, or?
I would say optimistically stabilizing. Yeah, in certain sectors we've seen some decrease, but in other areas they seem to pop up a bit more. I think in most key areas we are at least seeing stabilization, if not reduction. And this comes about through ever more stringent controls on certain aspects of IP. And that is certainly having its effect. I think we'll have to give it a few more years, but certainly the trend is in the right direction. But I can't overemphasize the need to use the available steps in China to protect IP, because whatever happens, if you're not registered, for example, a brand, if it's not registered in China, then you know, you won't have any chance of preventing others using that brand and taking advantage of it. So, you know, there's a big onus on EU SMEs to understand that and take some proactive steps. But certainly the situation is stabilizing, and in certain areas is improving in China through regulation.
Is there a difference between the online infringements and the other ones?
Yeah, I mean, online continues to be a thorn in the side. I mean, it's better than it used to be before the relatively straightforward takedown procedures that have been implemented through the, you know, the key service providers, Alibaba and so forth. And that has certainly helped. But, you know, on the other side of that, there is also some caution on the part of service providers too, to ensure that IP rights claimants do justify their requests to take action by demonstrating they do own those rights in China. So again, it comes back to this need to register in China. If you've got registrations, you've got the rights, then it's relatively straightforward to get the support of service providers to take off offending products that are being, you know, advertised on their sites.
Because e-commerce is increasing, so the number of infringements, is it the same level? Is it staying the same? Is it?
I would say it's pretty much the same at the moment, as it because of the we've seen an advancement in the way that service providers are able to step in and take action. And before that, we were seeing proliferation of fakes being, you know, sold and advertised on websites with relative impunity. So there is some control there now. But as you say, e-commerce is growing anyway. So we're kind of running to keep up in a sense with tackling the e-commerce counterfeiting issues. But my sense is that it's at the moment we're in a sort of a stable situation as far as that's concerned. Efforts are keeping up with the increase in e-commerce.
Thank you.
Thank you very much, Simon. Thank you very much, Petra. I think we have the time for a very last quick question coming from the audience.
Thank you very much for your presentation. I'm Gaia Bortolotti from Confindustria, from areas of Lombardy. It's a kind of specific question, but next year on the European level, also GIs for craft and industrial products will be recognized and protected. I would like to know if you foresee or see a window where China could recognize this kind of protection for, again, craft and industrial products, even at the trade level cooperation or something similar. Thank you.
That's difficult to answer. It really is. I don't really know. I think. Yeah, there's a certain politics or policies may have an impact on the speed at which further measures on geographical indicators are adopted in China. So, you know, we're in this rather funny sort of trade and political environment at the moment where, you know, in some respects we seem to be moving towards more collaboration, but in other respects, suddenly something crops up and that delays and changes things. So I can't, honestly, I don't really know, and it would just be a guess if I was to say. I mean, China has always shown that it's eager to improve its IP regime, and you see it evolving in such a speed, and they've come such a long way, and they will continue with momentum. So, you know, the backdrop is that China is determined to work to further enhance its IPR regime. So in that sense, you know, there's a positive outlook. You know, it just depends on GI specifically whether that's going to be of benefit. I would hope so, but it's the best I could say.
Perfect. Thank you very much, Simon. Once more, it has been a pleasure having you here today.